Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. I recently caught up with the folks at e-Immigration who shared a big announcement. Hot off the presses. Have you heard? E-Immigration is now integrated with the VisaLaw.ai. Over 10,000 users can now connect their e-immigration accounts to VisaLaw.ai, allowing them to generate expert letters, court documents, petition briefs, and entire case packets directly within their case management system. It's case management meets modern drafting, so you can build stronger cases faster than ever. The combination of e-immigration and VisaLaw.ai means what used to take hours can now be done in minutes. Just think how much faster your immigration workflows can be. Learn more at get.eimmigration.com/VisaLawAI, or of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. If you listen to the podcast often, you know how I believe it is very important to celebrate the good in immigration whenever you can. Celebrate your wins, especially with horror shows like what they're trying to do in the Everglades right now, and with it seemingly about to get a lot worse based on the bill that was just signed into law. I will not be saying the colloquial name of that Everglades facility ever on the podcast. So here's some dang good then. On July 1st, a federal judge in the Eastern District of New York set aside and postponed Secretary Noem's early termination of TPS for Haiti. As a result, as of the time of this recording, TPS for Haiti cannot terminate until February 3rd, 2026, nationwide. The case is Hecka et al. V. Trump et al. In the Eastern District. In addition to this welcome ruling, the decision coherently distills the complicated issues and the plaintiff's humanity, and contains excellent analysis on jurisdiction, the TPS statute, executive authority, standing, APA claims, post-Trump v. CASA, and much more. The plaintiffs were represented by our firm, Kurzban, Tetzeli & Pratt, Brian Cave, Leighton, Paisner, LLP, Just Futures Law, and Raymond Audain. Everyone's been fighting really hard, and we're all very happy with this result and honored to represent our plaintiffs. And then there's Refugee and Immigrant Center for Education and Legal Services v. Noem, a decision issued in D.C. District Court on July 2nd, 2025. This is a blockbuster ruling in favor of the plaintiffs that challenged the closing of the southern border to asylum seekers by Trump's January 20th, 2025 proclamation. Wins are still happening at federal court, y'all. Big wins. In no small part because the Supreme Court seems to have left open APA challenges in its Trump v. CASA decision limiting injunctive relief. And you know what? While we're at it, our firm achieved an emergency habeas and temporary restraining order in an absolutely absurd case Thursday evening, with literally 1 minute to spare before the entire court shut down for the holiday weekend. These are trying times, folks. Celebrate the wins for non-citizens. Celebrate your clients. Starting with wins like this first one from the Third Circuit. First up is Tipan Lopez, the Attorney General of the United States, published by the Third Circuit on June 30th, 2025. This case is about asylum and nexus. It's a split decision with Judge Hardiman concurring and dissenting in part. And the Third Circuit majority isn't playing around, being very, very clear from the beginning of what the BIA must or must not do on remand. Quote, "We remand the religious nexus question to the BIA with instructions not to apply the following: a subordination-based test, which rejects a protected ground as a central reason for persecution if it is subordinate to an unprotected reason, or an animus-based test, requiring a persecutor to show hostility towards a protected ground for it to count as a central reason." End quote. Restated, it sounds like the Third Circuit doesn't love matter of MRMS. Let's find out. Mr. Tipan Lopez is from Ecuador, where he converted to Evangelical Christianity. Quote, "Motivated by his new faith, he began encouraging young drug addicts to stop drug use." End quote. That upset the local Lopez gang, who dealt drugs. As a result, they did simply and absolutely horrendous things to Mr. Tipan Lopez, which I will not get into, and which even the immigration judge recognized rose to the level of past persecution. Mr. Tipan Lopez did not report the horrific events. Quote, "He distrusted the police because he had heard about and seen them taking bribes and letting criminals go free." End quote. Then he fled to the United States in 2023. Removal proceedings began after an arrest for domestic violence, although a conviction is not mentioned in this decision. Mr. Tipan Lopez applied for asylum and related relief and protection, but an IJ denied, believing that Mr. Tipan Lopez's evangelical religion was not at least one central reason for the past persecution, harm suffered, and feared. The IJ thought that the gang was just angry that Mr. Tipan Lopez was hurting their drug business. Insufficiently racial, too, to the IJ, despite a comment by the gang to the effect, and insufficiently political as well. Convention Against Torture denied, too, on the government acquiescence element. Then, as at least one podcaster suspected, the BIA denied by relying on matter of MRMS, believing in pertinent part that religion was, quote, "at most incidental or tangential to the more commonplace goals, including financial gain and furthering or preventing interference in a criminal enterprise," end quote. Which, of course, if the correct analysis, is just such a broad and easy way to rely on, to deny almost all gang-based asylum claims if that is indeed what the BIA wants to do. And to be fair, maybe that was the point of Attorney General Garland's BIA in matter of MRMS. Although I'm not sure whether Attorney General Garland himself was even aware of that decision beforehand or afterwards. The Third Circuit, however, cannot agree with the decision in this case. Rather, it seems to agree far more with Fourth Circuit precedent that is largely at odds with matter of MRMS. Before we get there, just what standard of review applies to what question is quite a nuanced thing with appeals these days in the asylum context, so give this decision a read when briefing your asylum and CAT petitions for review. On to the meat, though. Quote, "The BIA had defined one central reason as any reason that is not incidental, tangential, superficial, or subordinate to another reason for harm. But our court rejected the subordinate part of that test in Nadeshemi v. Attorney General," end quote. That's a 2009 Third Circuit decision, and I hope I didn't butcher the name. So it's not just Fourth Circuit precedent that disagrees with matter of MRMS, albeit this Third Circuit decision relying on was well before MRMS. Hierarchy of the reason for persecution just doesn't really matter, explains the Third Circuit. Quote, "A persecutor may have more than one central motivation for his or her actions. Whether one of those central reasons is more or less important than another is irrelevant," end quote. So yeah, that seems like a big deal. And LOL. Quote, "The BIA and MRMS acknowledged that this subordination-based test conflicted with Third Circuit law, but applied it anyway," end quote. The court doesn't seem to love that. Important here, of course, because the Third Circuit believes that the BIA applied this erroneous subordination standard in the instant case. Then Nadeshemi is still good law in the Third Circuit, explains the majority, and it governs here. Quote, "The BIA used MRMS to reject Fourth Circuit cases, which themselves rejected a subordination-based test for nexus. Its double negative amounts to the BIA adopting that test, which is directly contrary to our precedents, end quote. And this all with merely a citation and maybe a parenthetical to MRMS in the decision below. Take note in your case, everyone. Whenever the BIA literally cites MRMS, you may have a reversible issue in at least the Third or Fourth Circuits. Whether a protected ground is subordinate has nothing to do with the nexus analysis in the Third Circuit. Looks like the Fourth Circuit too, and I seem to recall maybe other circuits. It's probably an argument you should be making in every circuit, along with challenging just so much of matter of MRMS. And that's not all. Asylum law, including even the BIA in matter of Kasinga, and even recent DHS guidance, does not require that the persecutor have animus or hostility to the asylum applicant. UNHCR too. And, quote, international law is relevant because Congress created our national asylum process to align with international refugee law, end quote. Don't forget it. As an example of what the Third Circuit apparently sees as a potentially viable asylum claim, quote, a protected ground can motivate persecution even when the persecutor has no hostility towards that ground. For instance, gang members might attack an indigenous person because they want him to join their gang. In doing so, they might leverage to their advantage negative stereotypes or impediments he experiences as a result of his indigenous identity, not because of a dislike of indigenous people, end quote. This is all relevant here because the IJ expressly denied in part based on a belief that the gang had no animus against Mr. Tipan Lopez's religion or race. Flat out, it would seem, if an IJ or the BIA says the word animus, or for that matter, subordinate, during their nexus analysis, they're probably committing legal error, at least in the Third Circuit. And after all, quote, the Lopez castigated Mr. Tipan Lopez for preaching the word of God, and brought up his religious views and motivations on more than one occasion, end quote. The Third Circuit seems to see a nexus, at least to religion. On race, and despite those favorable holdings on not needing to have an animus, the Third Circuit did affirm the agency on race nexus. Although Mr. Tipan Lopez is indigenous, and although the gang used a racial slur against him, he didn't present enough evidence of a racial reason for the attack to the court. With a slur only used one time, quote, the racial slur was merely incidental to the persecution, end quote. So that's one example of what incidental means on nexus, everybody. When a racial slur is used one time, then the protected ground is incidental. Nor did the Third Circuit see a sufficient anti-gang political opinion nexus. On the Convention Against Torture, everyone assumes that Mr. Tipan Lopez will more likely than not be tortured if he returns to Ecuador, which is wild, by the way. Now, Ecuador has a high murder rate, and the Ecuadorian government has created a task force following a state of emergency. And Mr. Tipan Lopez does not have an example specific to him because he never reported the events to police. So to the Third Circuit, it looks like the Ecuadorian government might be trying, and Mr. Tipan Lopez couldn't really show that they would acquiesce, at least in his specific case. But even for CAT purposes, quote, it matters whether a government can prevent torture, not just whether it is trying, end quote. Efforts notwithstanding, the BIA is required, quote, to consider whether the government is capable of preventing the harm, end quote. Did you hear that? Failure to report isn't fatal in CAT claims, everyone. And that stems from the Third Circuit's 2019 Quinteros decision. Flat out again, quote, fervent but unsuccessful resistance to torture can be acquiescence, end quote. There is absolutely no, quote, bad faith requirement, end quote. Another big deal. Does this sound familiar to any of you litigators? Quote, the IJ here noted attempts, not results, and found only that Ecuador is trying to root out gang-related corruption, not that it is succeeding. We therefore grant Mr. Tipan Lopez's petition for review as to the CAT claim, end quote. Tangling with dissent for quite some time, the Third Circuit majority remanded with the instructions that I mentioned at the top of the case, and on CAT as well, in a big way. So congratulations, Robert Jackal, Rebecca Hofstadter, and Emily G. Thornton. of Legal Services of New Jersey for petitioner, along with Ann K. Dutton on amicus for the Center for Gender and Refugee Studies. Excellent lawyering. And that is Tipan Lopez, the Attorney General of the United States. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. Next is matter of AAFV, published by the BIA. The Attorney General and her BIA's blitzkrieg approach to precedential publication continues. A strategy exceptionally different from her predecessor's approach in just about every way. And it's another decision that the Attorney General has decided to make precedential where the non-citizen did not have an attorney advocating for him. And it's another decision overturning an immigration judge on the grant of Convention Against Torture Protection. Seems that the BIA and the Attorney General are trying to send a message to immigration judges. The case actually arises in withholding-only proceedings. The BIA does not say why, but it would likely be because either Mr. AAFV has been removed once before and re-entered unlawfully, or because ICE itself decided to order him expeditiously removed through a FARO, discussed in the Riley Supreme Court decision just last week. Either way, he would have passed a reasonable fear interview, and, as I mentioned, he even received cat protection from an immigration judge, ultimately, in those withholding-only proceedings. His claim was based on his being a bisexual criminal deportee with visible gang tattoos from El Salvador. Here, the BIA sustained DHS's appeal, therefore facilitating what will probably be a quick removal to El Salvador and placement in that Salvadoran gulag. Cat protection is a two-pronged inquiry, explains the BIA. An IJ must first determine what is likely to happen to the applicant if he is removed. That's a fact question. Then the IJ determines whether what is likely to happen amounts to the legal definition of torture. That's a mixed question of law and fact, meaning it's de novo review by the BIA. The claim, like so many, is based on El Salvador's express state of exception policy, where they immediately imprison people with tattoos as suspected gang members, something the BIA recognized likely happens in matter of AAR, episode 261. Indeed, quote, under the state of exception, which must be renewed monthly, security forces are empowered to arrest anyone suspected of belonging to a gang or providing support to gangs, end quote. I don't think anyone's disagreeing that then they're all put in these terrible prisons in El Salvador. The BIA agrees that Mr. AAFV is likely to be immediately detained upon his return to El Salvador as a suspected gang member with gang-related tattoos and a criminal history. Heck, we, the United States, are going to tell El Salvador about him, explains the BIA. But still, no torture. Quote, in finding that the applicant would suffer harm satisfying the definition of torture in detention, the immigration judge relied heavily on statistical information and country conditions evidence showing that some detainees and suspected gang members have been subjected to mistreatment, torture, or death while in detention, end quote. I believe Kilmar Abrego Garcia is talking about all of this right now in America. That is his own experience in a similar prison. I wonder if that evidence could be used in a BIA decision going forward. Because here the BIA is not overly impressed with the statistics that were relied upon, describing 90 deaths out of 95,000 detainees as of November 2022. Even if the number is actually higher, the BIA sees it as a legally insignificant, quote, small percentage, end quote. Moreover, explains the BIA, statistics don't establish, quote, that public officials caused those deaths or that the unspecified human rights abuses rise to the level of torture, end quote. I do wonder how BIA members would put on a cat case themselves if they were ever on the other side of one of these issues. I do wonder what their suggestion is if country condition evidence and statistics and all of that stuff is becoming less and less reliable to them. To the BIA, bad prison conditions aren't enough, citing to a long line of cases that not all circuits have always fully agreed with. The BIA, of course, relies most heavily on its 2002 decision matter of J.E. regarding prison conditions in Haiti. To the BIA, the Salvadoran state of exception and related, quote, policy of incarcerating suspected gang members as a method of addressing historic violence in the country appears to be a lawful enforcement sanction designed to protect the populace from criminal acts committed by gang members, end quote. The BIA is not interested in protecting people from that state of exception's abuses or excesses, it would appear. Nor does Mr. AAFV's bisexuality move the needle for the BIA. No individualized risk as many circuits require for cat protection, notwithstanding the, quote, human rights abuses, violence, and discrimination, end quote, that the BIA seems to recognize that such people experience in El Salvador. No doubt about it. This is a decision intended to deny cat protection to as many Salvadorans as the BIA can, even where everyone agrees that they will be locked up and likely harmed as suspected gang members upon their return to El Salvador. That is what this decision is intended to be. And as such, Mr. AAFV lost as well. And that is matter of AAFV. Our final case this week is Lanoue, Attorney General of the United States, returning back to the Third Circuit, this one published on July 1st, 2025. This case is about fraud or deceit aggravated felonies. Mr. Lanoue is a Canadian, so take note. If the country would just become our great, beautiful 51st state, all could be resolved for Mr. Lanoue. But alas, he came here 4 decades ago as a lawful permanent resident, and a decade ago, he opened a scuba school with his wife. A few years later, his scuba school was accepted into a government-funded program, which funded by a post-9/11 GI Bill that reimbursed him for teaching veterans how to scuba dive. Good work if you can get it. But Mr. Lanoue lied to the government about the program's details. He pled guilty to, quote, knowingly submitting or causing to be submitted false and fraudulent claims for payment to the Department of Veteran Affairs, end quote, in violation of 18 U.S.C. sections 287 and 2. Apparently it cost the U.S. government $3 million. How about that for a fact pattern? And if it's an I&A section 11843 MI aggravated felony, it makes Mr. Lanoue removable. An immigration judge held that it was, and the BIA affirmed. The Third Circuit did too, after getting through some preliminaries that we need not trouble ourselves with now. The aggravated felony provision at issue describes any criminal offense that involves fraud or deceit in which the loss to the victim exceeds $10,000. In issuing its rule statement, the Third Circuit cites to its Rad v. Attorney General of the United States decision from episode 35. And quite frankly, just seeing that citation gave me shivers if I recall that case's complexity. You remember that one? The case about the aptly named Canned Spam Act that had nothing to do with canned spam? OG listeners know. What a weird ride this podcast has been. Anyway, maybe this federal crime requires fraud, and maybe it doesn't. The Third Circuit doesn't care because it believes that it definitely requires deceit, and that's enough for the aggravated felony provision. Fraud or deceit is the requirement. The Third Circuit reached the deceit finding because the Section 287 statute requires that a defendant make a claim against the federal government, quote, knowing such claim to be false, fictitious, or fraudulent, end quote. That necessarily entails deceitful conduct. Quote, the mental state requires lying because the claimant must know the claim is false. That is exactly what deceit means, the act of intentionally giving a false impression by falsification, concealment, or cheating, end quote. Case closed on that front to the Third Circuit. This is one of the weirder aggravated felonies, though, as we all know, and it requires another showing, besides fraud or deceit. A loss to the victim or victims in excess of $10,000. The circumstance-specific approach rather than the categorical approach applies to that inquiry, meaning in essence that DHS can rely on a wider array of evidence to prove its case, so long as it does so by clear and convincing evidence. The Third Circuit saw that met here as well. Mr. Lanoue stipulated that his false claim cost the government between $1.5 and $3 million, and his plea agreement pegged restitution at $3 million. Mr. Lanoue, of course, disagreed. He argued that, quote, the loss amount should be lower than that amount of restitution because he used all of the VA money on classes for veterans, end quote. He argued that his conviction stemmed from him not having enough veterans enrolled, but that he still had some, and that the money he spent was on those customers, his veterans, and so that shouldn't count as government loss, because he was doing what the government was paying him to do, just not enough of it. It seems that's his argument. The Third Circuit was not swayed, given that full compliance with the program was mandatory to receive any funding. And Mr. Lanoue pled to falsely representing hours of instruction received by veterans, so I guess the court doesn't really believe him very much. Plus, the restitution order was clear on what parts were owed by him compared to other defendants, and it was $3 million. This means Mr. Lanoue is removable. But we're not done. Looks like he sought to readjust to LPR status through his U.S. citizen wife. Aggravated felonies don't actually bar that per se, right? But a CIMT does, meaning Mr. Lanoue needed a Section 212H waiver because an aggravated felony like this is pretty much always going to be a CIMT. Actually, that's not the argument. That's what I thought the argument was going to be, which, don't get me wrong, was going to have problems. But that wasn't actually the argument. Here's the argument. Apparently, quote, after the government started investigating his false claims, he thrice left the United States and thrice returned, end quote. Mr. Lanoue's argument is that he should have been identified as an inadmissible applicant for admission on each of those reentries and have been permitted to, at that point, apply for a Section 212H waiver. This is a benefit that he wants now, I imagine, because at those times in the past, he did not yet have an aggravated felony conviction, which probably bars him from a 212H waiver now. He wants to be able to retroactively apply for the waiver. Quite the argument. The Third Circuit did not agree. I personally am not sure whether you can retroactively apply for a Section 212H waiver under circumstances like this, but I don't know. More important to the court, Mr. Lanoue was not yet inadmissible at those times because he hadn't yet been convicted or admitted to the conduct as immigration law requires for inadmissibility. Quote, "It is not enough that the government was investigating or even prosecuting him then," end quote. That does not make him inadmissible, and it can't allow the government to charge him as an applicant for admission. So remember that quote for your applicant for admission cases in the Third Circuit. But it lost a day for Mr. Lanoue, stating that, quote, "Filing false claims against the government under 18 U.S.C. Section 287 is categorically a crime involving deceit," end quote. The Third Circuit denied the petition for review. And that is Lanoue v. Attorney General of the United States. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.